I'm ready when you are, Mr. Baker.
I'm just fine. Judge, just go.
Cole Younger Baker, he's charged in case number 14993. He's going to enter a plea to count 1 aggravated assault, receive a sentence of 4 years TDOC, suspended probation, supervised probation, complete domestic violence classes at Main Street Intervention. Pass all drug screens. There'd be 0 tolerances for any failed drug screens. He's going to enter a plea to count 5 domestic assault, misdemeanor assault, and receive a sentence of 1129, suspended concurrent to count 1. Same conditions as count 1. So plead on count 6 and 7, amended to an A misdemeanor, child abuse or neglect, 1129, suspended to supervised probation, and same conditions and lawful contact only with the wife and the children. Count 2, 3, 4, and 8 would be knowledge and so, Judge.
All right, Mr. Baker, raise your right hand. Let's place you under oath.
I solemnly swear or affirm the testimony I give in this case with truth, whole truth, nothing but the truth, so help me God.
State your full name for the record.
Cole Younger Baker.
Mr. Baker, you were here today and you heard your lawyer indicate what the, and Mr. Baker, Mr. Olin Baker, is this a guilty plea or a no vote?
This is going to be a best interest guilty plea, Judge.
Right.
Plead guilty on this.
You've heard what the agreement is regarding your charges, but have you seen or been shown a copy of those charges and talked them over with Mr. Olin Baker and discussed with him the range of punishment as well as any possible defenses you might have?
Yes, Your Honor.
Well, it's indicated that you want to enter a plea of guilty to these charges. Do you understand you have a right to plead not guilty and have a speedy and public trial by jury?
Yes, sir.
You understand if you went to trial, you'd have the right to have a lawyer and have one appointed if you cannot afford your own.
Yes, sir.
You understand at trial you would be presumed to be innocent until such time if ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, sir.
You understand that if you went to trial, you and Mr. Baker could confront and cross-examine every witness the state called. You could bring in your own witnesses by using a subpoena.
Yes, sir.
You understand at trial you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading guilty, you're waiving your right to a trial and to an appeal, and the state, and all that will happen is that I will find you guilty according to this agreement.
Yes, sir.
You understand that's going to result in a number of convictions, and those convictions are going to be used in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes, sir.
I'm required by law to advise you that anyone who is convicted of domestic assault or domestic violence is by law, federal law and state law, automatically prohibited from ever purchasing, owning, or possessing any kind of firearms. And that conviction, that is a lifelong prohibition from the moment of conviction for domestic violence offense. You will never again be able to lawfully possess or buy a firearm. You understand that?
Yes, sir.
All right.
Judge, may I have a moment with Mr. Baker? Judge, I have a typo on this form. The effective sentence is actually 5 years. The 6 and 7 is consecutive to count 1. 6 and 7 are concurrent to each other, but consecutive to count 1. So that's an effective 5-year suspended sentence.
All right. Mr. Baker, do you understand everything I've explained to you thus far?
Yes, sir.
Do you wish to waive your right to a trial
Yes,
and
sir.
to an appeal? Excuse me. Excuse me. Do you understand if you plead guilty, the court or the state could ask you questions? My understanding, this is a best interest plea, so therefore the state's going to give us a factual basis. Is that correct? Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your will? You understand I can't accept your plea unless I'm satisfied that there is a factual basis for it and that you are in fact guilty.
Yes, sir.
All right, then I want you to listen to the state's evidence. If you'll step aside and let her have the podium, she'll tell us what the evidence would be at trial.
Yes, Judge, if this case had gone to trial, the state would expect to be able to show that on July 26th of 2024, Humphreys County deputies responded to a call out on Gravelly Run Road, which is in Humphreys County. Once there, the detectives, Stephanie McFerrin and other deputies made contact with Miss Allison Baker and her mother and her two small children, who I believe were 2 and 3 years old. She told them that her and her husband had been arguing, that he had been upset with her, that she was trying to leave that morning in her vehicle. He came to the vehicle, the children were in it. He drove her out of the vehicle, put his arm around her neck, drove her into the house, choked her multiple times. She said she was unable to breathe. He threw her on the stairs inside the garage. This happened for a period of about 30 to 45 minutes or so, and the children were left unattended in the vehicle while this was happening. Her mother also came by because she suspected something might be going on to check on her daughter. And when she walked in the house, Mr. Baker shoved her out the door and told her, "I'll hurt you like I hurt her."
Well, Mr. Baker, I'm not asking that you agree with those facts, but do you understand that's the state's evidence at trial?
Yes, sir.
You still wish to plead guilty according to this agreement?
Yes, sir.
Are you satisfied with your attorney's services?
Absolutely.
You feel like Mr. Olin Baker has done a good job of representing you confidently?
Great job.
And Mr. Baker, you know of any reason he should not enter this plea?
I do not, Judge.
Then I'm going to give you two forms. The first is this notice of firearm disqualification based on violence, domestic violence. The second is a disposition form where he's going to have to fill that out later. He needs to fill it out and dispossess himself of any firearms. So.
You turn this back in with.
Yeah, just before he leaves, he needs to fill that out. All right, then Cole Younger Baker and docket number 1. Did I ask you, Mr. Baker, you know of any reason he shouldn't enter the plea?
I do not.
Anything further from the state on this? I'll take it as no. Docket number 14993, upon your plea of guilty to count 1, I find you guilty of aggravated assault, sentence you to 4 years, Tennessee Department of Corrections that will be suspended to supervised probation. Count 5, you're found guilty, sentenced to 11 months and 29 days in county jail, and that will be served concurrently with the prior count. That was count 5. Count 6 and 7, you're found guilty of misdemeanor child abuse or neglect, sentenced to 11 months and 29 days in county jail. Those two will run concurrently with one another, but consecutive to count 1 for an effective 5-year sentence. As a condition of your probation, you must complete the domestic violence classes at Main Street Interventions in Dixon, Tennessee, pass all drug screens with a 0 tolerance for any positive drug screen. One positive drug screen, you're going to serve as 5 years in prison. All right. He needs to see the probation department. Counts 2, 3, 4, and 8 are all dismissed as a part of the agreement.